Good afternoon and welcome to our program. My name is Ed Yohnka. I am the Director of Communications and Public Policy for the ACLU of Illinois. And we want to thank you to this program discussing Illinois' new Pretrial Fairness Act. We're joined by a number of guests this afternoon. We've got about 40 minutes worth of programming. And we have time for your questions, which you can feed into the chat as we go along. I do want to mention that this afternoon's program does have live captions. To turn those captions on, please click the arrow that's next to the closed caption button at the bottom of your screen and choose Show Subtitle. That way you can see the captions and follow along as we work through the program this afternoon. I'm again want to welcome you. It is obvious that there has been an enormous amount of conversation about the end of money bond here in the state of Illinois. And we're really fortunate to be joined by some experts today who can help us in terms of understanding what the current system is and what the new law will bring. And we are especially fortunate that as a beginning for our conversation, we're joined by someone who is a prosecutor who makes decisions about seeking to hold people, as well as a public defender who represents people seeking to be released from jail before trial. So to begin, we're joined by Rinehart, who is the state's attorney for Lake County, Illinois. We're joined by Sharone Mitchell, who is the Cook County public defender. And we're joined by Ben Ruddell, who is in the advocacy department here at the ACLU of Illinois and has worked on these issues for a number of years. So, Mr. Rinehart, I want to start with you because I think one of the things we never do in this conversation is before we talk about what the new law is and what it will do, can we actually talk about what's in place right now? You know, how does our current bond system actually work?
Yeah, thank you very much. I want to thank the ACLU for hosting this event and the organizers for inviting me. I appreciate this opportunity. I think that's a great way to start the conversation, Ed. As I've been talking about the Safety Act in a lot of places, I've realized that is really the best starting point. Currently, an individual who is accused of a crime might be arrested on the street, or they could be arrested based on a warrant. I'll talk about a warrant in a moment. Currently, they're arrested on the street and they are brought before a judge. They have to be brought before a judge within 48 hours under the current law. And the judge will then either decide if they're immediately released on a recognizance bond, or as in most cases that we'll be talking about tonight, whether or not an individual should have to post some amount of cash. I'll speak to Lake County because there are some idiosyncrasies between different counties. But as for Lake County, the judge will at that time look at a variety of factors. They'll look at a risk assessment. They'll look at the priors. They'll look at what the prosecutor is asking for. They'll look at what the defense is asking for. And they'll also ask an interesting question sometimes of the defense. How much money can the defendant post, or how much money does the family have? I think that question kind of makes it really complicated too, because what are they trying to accomplish with that question? Are they being given truthful information? And the judge will say whether somebody should be put in custody by saying how much money they have to post. That's how they express their ruling. Their ruling is expressed in cash. It might be, say, $100,000, which means somebody has to post $10,000. Any member of a family, any friend, anyone whatsoever can say, I want to post $10,000 cash on behalf of Rinehart. Yes, they have to leave their own name, and that's about it. So that's how the current system works. A dollar amount is expressed, and anyone in the world can come and post cash for that individual 24 hours a day. So and then that person is released, and they're promising to come back to court.
Yeah. So let me just ask a quick follow-up. So for years, I've heard this process described in various ways. And one of the phrases that's often used is to say that this system is like a conveyor belt, that people just move through court, they're assigned that dollar amount, and they move on through. They either can pay it or they can't pay it. Is that a fair assessment from your perspective?
Yes, these bond hearings go very quickly. They might be a matter of minutes. Sometimes the attorney, whether it's an attorney from the public defender's office or a private attorney, may only have a few minutes with the individual on really what turns out to be a massively important decision in that person's life. They're about to be potentially put into custody away from their family, away from their job, and away from their educational opportunities. They may lose their housing. This is a big moment in the case, but it can be done very, very quickly. Attorneys are not entitled to a lot of information at that point. And so it can be done incredibly quickly. And it is a little bit like comparing real estate. If somebody has prior backgrounds, then that number is going to be set based on what the judge did the day before or what they have learned from their colleagues. That doesn't make the judges bad people at all, but it makes them people. And the judges are expressing these numeric values. You're not in or out, sir. It's a numeric value, 100,000, 150,000. They're doing that. They don't know the individual's tax returns. They don't know the size of the person's bank account. They don't know anything about the family. Or I'm going to say it from the prosecutor's perspective. Public Defender Mitchell may look at me a little bit strange when I say it. They don't know about their criminal associates' access to money, right? And so there are different factors about all of our money, and it's unfair. That's not the question you're asking me, but it's an unfair way to do it. But just mechanically, judges don't have bank account access or 1040. They don't see their tax returns. So it's a very it's a process that I think warrants a lot of criticism today.
So Sharone Mitchell, you hear that description, and obviously you, among others, including the ACLU, have pushed for the end of cash bail in money bond here in Illinois. So what's the purpose then? What's kind of the policy goal? What's the desired hope in terms of ending this process as Mr. Rinehart describes it?
Yeah, I think some may describe it as a conveyor's belt. Others may describe it as an auction. The use of money to make decisions about whether somebody should be in or out is one of the most abhorrent policies we have in a system that is filled with abhorrent policies. And the fact of the matter is the vast majority of people in the criminal legal system are poor. It's the reason why the Cook County Public Defender's Office represents the vast majority of people in the system, over 80%, somewhere between 80 and 95%, probably more closer to 80 and 90. Using money as that determining factor is just a bad way of making these decisions. As State's Attorney Rinehart talked about, is such an important decision. We know when people are stuck in jail, they are more likely to plead guilty, and they're more likely to serve a longer criminal sentence than they would if they are out. They lose access to their family, they lose access, real meaningful access to their attorney, and they're just put in a bad situation. With that said, we think that ending money bond and moving to a system where we're having more realistic conversations about whether somebody should be in or out is just a better process. It's a better process for communities, and it's a better process for the accused person. Now, let's be clear. This isn't going to be a walk in the park for our clients. There will be some people that will be detained, and we at the Public Defender's Office believe that pretrial detention isn't something that we should be using as often as we do. But with that said, we believe that the Pretrial Fairness Act is a strong step in the right direction. We're talking about building a system that is more just and building a system that is more fair for people who are accused of criminal offenses in the state of Illinois.
Before we turn and talk about the new measure that's going into effect on January 1st, Sharone, I wonder if you could talk a little more, expand a little more on this notion of, what the harms are, the idea that, and I think sometimes for people of privilege, it's a little hard to comprehend how someone loses contact with family and other things, by a few days in jail. And I wonder if you could just sort of share a little more about that and how that experience does affect people.
Listen, we know that when poor people lose jobs, they lose family stability, they lose educational opportunities because they can't post this cash. And we know that there are serious public safety impacts when somebody is incarcerated. Too often we think about public safety in one way. We think about public safety in terms of locking up people. And what we don't talk about is how we impact public safety when we do lock up people. We also talk about violence, and I just can't let it go when by allowing us to talk about violence in one particular way. It is violent when you force a grandmother to make a decision about whether they should pay the rent or pay for their family's freedom. That is violence. That destroys communities. And we know that our system pulls literally tens of millions of dollars out of communities that can afford it the least every single year. And we know that that burden is put on Black and brown women. Go to 26 in California here in Chicago, Cook County. Look at the line of Division 5 of who's bonding out people, and it is Black and brown women. This burden needs to stop. This burden needs to end. And there is violence in pretrial incarceration, and there's violence in the payment of money bond. And we believe that the pretrial fairness offers a new path for making these decisions.
So, Mr. Rinehart, before I turn to my colleague Ben, I noticed you nodding, and I wondered, do you share some of those same notions about the concerns about the current system?
I think what Public Defender Mitchell, just said is that this act is a recognition that disparities in our justice system are also a driver of crime. I think most people do accept that disparities in education, in healthcare, in housing, in economy. I think most people accept that drives crime, and that people may differ on how urgently to react to that. But I think what Public Defender Mitchell just said is the correct opinion, that this act finally recognizes that disparity in justice outcomes, and in this case, pretrial detention, also drives crime, because it increases family separation, leads to economic instability, leads to psychological trauma. That's the violence that Public Defender Mitchell is talking about. And we have to acknowledge that is also a driver of crime, the thing that every one of us on this call and everyone that's listening to us wants to stop. It's just a question of how creative and how urgently are we going to work to do that. And I think the PFA does that.
So, Ben Ruddell, all of this sort of energy, the philosophical drive of trying to end these harms goes into passing the Pretrial Fairness Act. I wonder if you can talk a little bit about how does this actually look when it gets implemented on January 1st of 2023? What is the process? How is it different than what Mr. Rinehart described? What do you see moving forward?
Well, thanks, Ed, and thanks to our guests for being here. As I think, people, the other panelists have alluded to, on January 1st, we'll move to a system where instead of looking at an amount of money that a person or their family is able to pay as a determinant of whether they're going to spend the time before their trial in jail or in the community, we're going to be looking at the things that actually courts have always supposed to have been looking at in making these decisions, which are, if released, would the person be highly likely to run away, to flee the jurisdiction of the court? That's one of the primary reason that bond exists, or why, the stated reason for its existence is to make sure that people come back to court. And then the second reason is because the court finds that if the person is released, that there's a risk that they're going to harm another person that can't be mitigated by other conditions of pretrial release, and they need to be detained for that reason. So we're moving from a cash-based system to a risk-based system. And we know that such a big change will not be perfectly seamless. There will be bumps in the road. It's one of the reasons why this was passed 2 years ago with a 2-year effective date, or a delayed 2-year effective date to give stakeholders around this state ample opportunity to prepare. And they have been. Judges, prosecutors, public defenders, law enforcement, advocates, other stakeholders from the system, from all over the state, have been meeting in various statewide working groups organized under the auspices of the Illinois Supreme Court, and in local working groups like they have in Cook County and other places to identify implementation challenges and solutions to those challenges, to make sure that this rolls out as smoothly as a big momentous change like this can. And so, part of that is we expect there may be some clarifications and changes to the law itself when the legislature goes back to Springfield in the fall veto session. And just to name one of those types of things, to give clearer guidance than currently exists under the law as to what happens with people who are either released on a money bond or in jail on a money bond that they can't afford on January 1st. What happens to those folks? The law is clear that what needs to happen is an individualized hearing to determine whether or not they're going to be detained or continue to be detained. But I think we all agree that the law could be, could say more, especially because you have some stakeholders claiming, I think disingenuously, but claiming that they're prepared to have the jail doors open on January 1st and everybody's going to get out. That's not the intent. That's not what the law says. That's not what anybody in good faith believes. But it's a thing that people are saying, and I think we need to just give more guidance about what the actual process is mechanically in order to have those detention hearings and those conditions hearings that we need to have. But these are implementation challenges that really go to implementing the bill or the law as it was passed to effectuate the intent of the General Assembly. And I think you see other folks proposing some changes that would completely turn it into something else entirely. So we could talk more about that later, but just wanted to foreshadow that in answering your question.
And can I jump in here?
Please.
And I think one of the most important things to think about as we're talking about implementation and thinking about how we're going to make this new law work, I think it's also so important to think about how broken the current system is. And while we want to get the new system right, and while we want the new system to be perfect, everybody's fighting for that. Everybody's working really hard for that. I think in the same debate, we have to acknowledge that the current system does not work for so many people. Whether you are a person that believes on more the law enforcement side, that people shouldn't buy their way out of jail, or more on my side a little bit, that there should be poor people stuck in jail just because they're poor, I think lots of people from lots of different shapes, sizes, and colors can agree that the current system is broken. So when we have these conversations about how we're going to implement this new law, I think it's important for us to know that our competition should not be perfection, that we always try to get for perfection, but our competition should not be perfection because the current system is so imperfect. In fact, it's so broken.
I want to come back to that in a moment. That's a really important point. I want to pick up on a specific piece of the rollout and ask Mr. Rinehart to talk about, one of the things we've heard a lot about, and Ben mentioned, is a risk-based system. And there's been this discussion about the use of a risk assessment tool. What is that from a practical perspective from your office? What does that tool look like? What is that? How does that work?
So these the tools, the public safety assessment, the tools that are going to be used. I want to say this, and any one of us could have said this prior to this point, but I think it's really important. We've been working on getting this. We've been working on a new system for at least 5 years, maybe more. Right, Sharone.
Yeah.
There has been constant studies. There's been constant input. there was a state's attorney, there was a Supreme Court task force that included state's attorneys, police chiefs, that recommended the release of nonviolent offenders. And state's attorney leadership, statewide state's attorney leadership, and police chiefs were on that. And so in that work that they started doing, I think in 2017, they eventually developed the public safety assessment, which is a study of thousands of individuals over 300 US jurisdictions that looks at what has led to risk in the past. Now, there's been some criticism that we have to be very careful with sort of actuarial instruments. I see Ben nodding. We have to be very careful with actuarial instruments. I agree with that concern, but it is what has sort of been adopted by the judiciary at this point to understand whether people are a risk to the public. But at the end of the day, it's going to be more about what the charge is and what the evidence is in the individualized case that is going to lead to whether or not an individual is a threat to other people. And now, as I said earlier, we do this in a few minutes and a number is given out, $75,000 next case, right? Instead, we're going to have a system where there's a detention hearing a couple days later where prosecutors, police, victim specialists, public defenders, private attorneys are going to be able to focus on those who are being sought to be held. So the judge and the parties will then be able to argue, not just as a conveyor belt, but argue about whether or not an individual is a threat to the community based on the evidence in the individualized case. It is a much better system. It will help prevent wrongful prosecutions. We had one in Lake County a few months ago where my office was able to release a juvenile some hours after the arrest. Those hours are a problem. I'm not wiping them away, but they were hours and not decades. And it was because there were resources at the front end of the detention hearing, which is what we use in our juvenile system.
So one of the things about this dialogue and this discussion, that happens in my office as well. And I feel
I'm not waving my hands enough when I speak.
Yeah. Obviously, this effort, as you mentioned, going back to 2017, was statewide. I want to invite in now, as we continue this conversation, I want to invite in Carol Leff, who's the president of the Champaign County chapter of the ACLU, and Ken Page, who's the president of the Springfield chapter of the ACLU. And I want to go back to the point as we pick this up. And Sharone, I'm going to start with you, and everybody should feel free to chime in. Your point about sort of not comparing this to, to be perfect, but to the broken system we have is, it really sort of reminds me, we've had this, multi-million-dollar political ad campaign that's been running recently, which has demonized and suggested that the current system is good and this will be bad. So I wonder, when you hear that, I just wonder, I guess, really how you all experience that right now, and how you feel about that as you think about these issues and think about what happens after January 1st.
Well, I would like to say that Sharone was point on when he said that it's better than the system that we have. Nothing is perfect. And what we found is that the opposition to this wanted to be perfect. And anytime there's any issue that deals with criminal justice reform, the opposition says it has to be perfect, and which is really interesting. But they never say that the system that we have now is flawed. It is broken and it's not working. And this is better, and we can improve upon what we will have. So Sharone was spot on, and I think that's very important to remember. Everything is not going to be perfect because we are imperfect when we put it together. But that's important to know that we know that everything is not perfect, but we will build on what we have to make it better.
Mr. Rinehart or Sharone, Ben, you guys want to weigh in on this?
Well, I'll let Carol jump in.
Yeah, okay. I just wanted to say that an earlier point is really important. People in the daily news headlines see somebody arrested with a gun, somebody, some other kind of crime. They can't see that violence behind the scene that is happening to the families. And somebody asked in the chat, Are people under pressure to submit to a plea bargain because they're stuck in jail week after week, month after month? Of course they are. I mean, it's so something that people have to see both sides of the story and understand the damage that this is doing. And it's not just rhetorical. I mean, there are lots of studies on this now.
Yeah, and I guess when we think about that, the unfortunate political campaign, the advertising campaign that is fear mongering around the Pretrial Fairness Act. It's repeating a playbook that we've seen in other jurisdictions that have done bond reform, where, without evidence, but with a lot of lurid videos depicting violence or, people's mug shots, things like that, all of which pertain to the current system, by the way. The Pretrial Fairness Act is not in effect right now. So when you see, things happening under the current system that are being put out there as reasons to be afraid of the Pretrial Fairness Act, it should ring pretty hollow if you understand that the Pretrial Fairness Act is not even in effect yet, and those are failings of the current system. But I think one thing, and State's Attorney Rinehart alluded to this a little bit, part of this is it's just politics. It's folks who are, sort of employing an old 1980s, 90s tough on crime style political playbook to try and, use fear, which is a very, powerful motivator sometimes, to try to make people feel unsafe and vote in a certain way. And they're willing to, spread lies and misinformation to do that. So that's part of it. And you've also got system actors who are losing power and who are, who are working kind of hand in glove with that. And, I think like what State's Attorney Rinehart said that spoke to me was, that people are going to actually have to argue, in these, to detain somebody pre-trial for the long-term period of time between their arrest and their trial. There's going to be actual lawyering that goes on, by the prosecutor, and actual findings that need to be made by the judge beyond $75,000 or $20,000. That is not that has nothing to do with risk of flight or of harming somebody else. But so, I think, part of the pushback from some prosecutors is the additional, work, frankly, that they're going to have to do in order to put somebody in jail, and the accountability that the law, creates in a prosecutor's office to seek detention, to prove what needs to be proven, as opposed to just asking for a high number. And, if the person is jailed and they're able to bond out, then to say, that's, not, I have no accountability for that. This is a system, the Pretrial Fairness Act is a system that will require more of all of us, because what we're doing now, we need to be better. We're failing to deliver fairness. We're failing to deliver safety, and we can do better. And the Pretrial Fairness Act will ask more of us all, but will result in more fairness in the system and more safety in our communities.
Ed, can I just jump in on that too?
Please. Yeah.
So, and let's not also forget, it is going to be more work on some cases. And how much of life, how much of leadership, how much of institutions are about deciding what's important or prioritizing. It's not just good that it is going to be more work. And as a prosecutor, I embrace that more work, but it's because of my next point, because it's going to be on the violent cases, because it's going to be on the cases that should be at the top of our system for the victims. That's why every victims group supports this. Nobody's ever, I keep saying, I've been saying it for weeks, nobody's pinned down the main opponents and said, now, why do the victims groups agree with the reformers? They still haven't answered that one. Every victims groups believes in this for a variety of reasons, but one of the reasons is that we are going to be moving our victim specialists to be working in those first 48 hours. Think about how important those first 48 hours are after an offense, to collect new evidence, to connect with a survivor. those 48 hours are going to be important, and they're going to be about the most serious cases in our system, instead of the way it is now, where everything is just a number. Everything is a number. And there's no extra work in those first 48 hours because of some case. There's no sorting, I guess. There's no sorting right now. Everything is just a number. And also, prosecutors don't know whether or not somebody is going to post or not post based on the number. This is a system where we're going to know this person is going to be detained, this person is not, they're going to be released with conditions. And that sorting mechanism is very important in large systems, right? If we were only talking about 3 cases, we wouldn't have to worry about large sorting mechanisms. But that's one of the, I think that's one of the unheralded benefits of the reform.
Sharone, you want to weigh in on this before we move on?
You know, I forgot the question. That wouldn't stop me from talking, but since we have a limited amount of time, I will let us move on.
I wondered if you wanted to just talk about the politics of this for a moment.
Yeah, like you know, like Ben said, listen, this playbook is not unique. The amount of money may be a bit shocking, but we see all over the country, whether reforms are big or small, they are met with opposition. You know, part of that is because, you know, the criminal legal system, most of what we've done, and me and Attorney Rinehart have talked about this, most of what is done is because it is what was taught to us. And anytime you disrupt that system, you're going to get a natural pushback. You know, like Ben said, this is going to ask us to do some very different things. For public defenders too, quite frankly, it's not just prosecutors, it's public defenders, because guess what? This is a very important decision. Once a person is detained, their chances of being getting the best outcome they can is severely reduced. So it's going to be a lot of work on us. That's why that sorting is so important, so that we can reserve our resources to have real conversations about the cases that really do present that deserve the most attention, as opposed to the status quo where we spread that out and we've kind of laundered the decision of who should be in and who should be out to a guess around money, to this market, to this auction, to this conveyor belt. With that said, you know, I just hope that people can see through the lies. Listen, I think that there are critiques that will be had, right? There are critiques that will be had about any change, but I think it's important for people to know that they're being lied to because of politics, right? We can have a discussion about the details, and we will have discussions about the details. Every law is changed a little bit. Every major law is changed. We're still passing laws about the sale of alcohol. But let's be very clear. We are being inundated with lies about this law, and we are inundated about lies about this law because people believe that there's political gain in that fear-mongering and in those lies.
And in protecting the status quo of this current broken system, as you say. So, Carol, you know, Champaign County is a place that's long had a very active kind of local coalition supporting the end of money bond. And I wonder if you could talk a little bit about what you and your chapter is doing, you know, on the ground to support the Pretrial Fairness Act, and sort of what it looks like somewhere outside of the Chicago area. And you're on mute.
Okay, thank you. But first, I want to say, in a way, it's unfortunate this act is going into effect right after an election, because that just amps up the amount of, you know, hysteria. So, no. So what we're doing locally, and I think it goes back to the summer of 2020, the local bailout coalition, which has an active branch here. And most of what they had done until now was try to raise bail money in a revolving fund. Asked us to endorse the Pretrial Fairness Act. We immediately turned to Chicago, found out they were already and had for a long time been deeply into this. Okay, so at that point, one of the most important things we did the first year, and may well be useful in this coming session, is you know, support campaigns for legislative witness slips in support of the bill. And what we've discovered is once we get people to do one witness slip on any issue, they're much more likely to now know that's not hard. And ACLU incidentally sends out links. So for our bills, it's it's even easier. And it's a very important tool in a general democratic toolkit, not just in this one. Okay. Another thing we've done this past year is engaged in the Bailout Coalition's broader court watching project, which is several downstate chapters and also Chicago have done this, and their report on our findings, not just our findings on the state's findings, are out now. Okay, so I'll say something in the second round of questions about why that court watching was important. Okay, but the main thing I want to say about what we've found locally with our ears to the ground is it's amazing how many generally well-informed people on a range of issues don't get this, don't understand it, don't know what it's about. So if you're in a network of organizations, one of the most important things that anyone can do is inform themselves on this issue, and then make sure that people understand what it's about. Some of my best friends, I'm embarrassed, don't understand what this is about. Okay. So what we've been doing locally is a lot of outreach. We've been tabling at farmers markets, at the YMCA, at Pride Fest, which in our local Pride Fest is in September. I don't know why it's different from the national one. And other kinds of places where we have a chance to explain what this bill is, okay, and why people should be paying attention to factual information as opposed to the other kinds of things. So all I can say is talk to people. You'd be surprised how many people that you would have expected have, especially in an election year, a broad understanding of this, but turn out only to have heard about the purge, right? Have only heard some of the TV ads and local. We also have written to local papers trying to counteract some of the misrepresentations of the act. Okay, so talk to people.
So Ken, speaking of talking to people, a couple of weeks ago, you had a forum in Springfield to talk about this. And I wonder if you could just talk a little bit about some of the things that you heard there, some of that experience, and what people knew, what they didn't know, what they were concerned about. Like, what did that look like?
Well, in Springfield, we did have a forum, and it was well attended. And the misinformation was unbelievable, the amount of misinformation that was being disseminated through social media and regular media, print media. That misinformation was just overwhelming. And it was unfortunate that misinformation was being disseminated so quickly. And the people that were for this PFA were almost silent, and we spent time trying to catch up with that, to cover that misinformation. So we felt that it was important in Springfield because we knew that the misinformation was just overwhelming. And so we decided to have that community forum. And it was a great event. And the turnout was great. The people that needed to be there were there to spread the right information, and they wanted to get that right information out. But I would like to say this, that, it's something that hadn't been covered. I think that when someone opposes something, especially criminal justice reform, they bring that Willie Horton thing in, and they Willie Horton the entire thing. So, it's going to be this great purge, and they will be let out. We already know when that great purge and who they are talking about, because the majority of people incarcerated pre-trial are going to be Black and brown people. So, you hear that, and of course, poor people on top of that. So you hear these things and that misinformation but that whole issue with money, and there was an elected official, a county official that said, I'm not exactly sure what county, he said their county, they had built their staffing and everything on people being incarcerated. And you look at those county jails, there's a lot of money that's being made on phone calls and commissary. Those things, that's why there's a lot of opposition to things, because the status quo, they're living off of the backs of poor people. And it reminds us of Ferguson, Missouri, that what they were doing in Ferguson. So that is happening a lot. And that is not being put out there, and the truth about that as well. So, but in Springfield, we had the opportunity put information out there that was correct, and it was important. And also the media covered us, and they gave us a fair chance to do that. So we're very happy that we had the opportunity to do that and get people involved and excited about something again. And so they went out, the other groups that work with us.
So Ben, and then I want to bring Mr. Rinehart and Sharone back into this conversation. There's, one of the things you hear is, oh, if we don't have bail, there's no inducement for someone to show back up for a court appearance. What do we know about that? And I wonder if the two of you can then talk a little bit about the other tools that kind of exist, for ensuring that people return in terms of making an appearance.
Yeah, thank you. And like, as I said earlier, the primary reason for bond, monetary or otherwise, conditions of release or, under the current system, monetary bond, the whole reason we have it primarily is to make sure people come back to court.
Right.
We know that when someone fails to appear for a court date, it's often not because they are hiding or trying to run away from the jurisdiction of the court. They're on a bus to California or to Mexico or something like that. Actually, most of the time, the vast majority of the time, people don't make their court dates because of issues with transportation or childcare, or because the person simply forgot about the court date. There's no evidence at all that money bond is doing anything to improve appearance rates. In fact, bond funds that, Carol was talking about the bailout coalition in Champaign, people who raise money and pay others bail to get them out of jail. They have observed that people who the bond funds bond out come back to court at a higher rate than people who pay their own bonds out of their own pockets. What that shows you is that it's having support and simple assistance like phone reminders that make the biggest difference in helping people come back to court, or a bus pass, for instance. Under the Pretrial Fairness Act, we hope to see courts utilizing the tools that work, rather than issuing, waiting till after the fact when somebody doesn't show up, maybe for an innocent reason, and then issuing a warrant for their arrest and just sort of deepening unnecessarily the person's involvement in the criminal legal system. We can do better by giving somebody a reminder on the front end. We do not have to require money bond. And in fact, jurisdictions that have moved away from money bond, who have eliminated it, like New Jersey has mostly gotten rid of the use of money bond. They have not seen some rash of, people not coming back to court because of that. Like it's the places where it's been done, it does not bear out the contention that we're going to see a big rise in failure to appear in court as a result of this.
Sorry. I just want to say that watching in the courts locally, you see that at the hearing, the people who are able to make bail, they're given a piece of paper that tells them when their next court date is. And you can always go online and try to navigate the court calendar to figure out when your next date is. But that requires, I had to learn myself. So yeah, one of the problems is people may actually just screw up and, just aren't reminded, aren't given any kind of follow-up. So it's on them. And that's part of why the Bailout Coalition works, is that they have that support.
So I want to jump a little bit here and go back to Eric Rinehart and ask, kind of another thing that sort of we're looking at here is, we've all heard the number of prosecutors from across the state who have opposed this measure. They are the people who are, some have filed lawsuits and et cetera. I wonder if you could just, what brings you to supporting this measure? I know you've talked about some of this before, but in the face of all of this, it would have to be really a lot easier to just go along with the crowd, isn't it?
Yeah, I was going to just answer your question with one word: leadership. No, I think you have to look. We have to fight for what we believe in. I think that this reform does two things. It tackles the safety side of it by keeping victims safe from the most violent people. That's why every victims group supports it, and it addresses the disparity, which the justice system has never really addressed so directly. And I don't remember if it was Ben or Public Defender Mitchell. But it's not as if the anti-reformers acknowledge the second thing. I'm still fighting for an equity statement in my county from some leaders about the disparities in our Lake County court system. And now I'm the state's attorney. And so now I have some responsibility for the disparities we see here. And one of the ways that I want to address those disparities is by supporting the Safety Act. I think we have an imperative moral duty to address the disparities that it seems like most of the people can see. I think more average Illinoisans will acknowledge the disparities in our criminal justice system than some of the leaders of the criminal justice system. And I think if you polled the leaders of the criminal justice system, if it wasn't a blind poll, I don't know that they would want to acknowledge that. And so we finally have a reform that is going deep into the cause of that. And it's not going to solve every disparity issue. We know it's racial profiling. We know it's implicit bias at the judicial and prosecutor decision at the probation officer level. We know this isn't going to solve it, but it is finally a reform that addresses it. And I am proud to be a state's attorney that supports this reform, that is finally doing something. And for the people who still are impacted by those disparities, frankly, those disparities today that can't be solved even on January 1 itself. I understand that it hasn't come fast enough. It should have come decades ago. But we have to start this process now. We have to acknowledge the disparities in the system and say that this reform addresses it.
So I want to kind of pivot into the some of the questions that we're getting along with this. So I wonder, Sharone Mitchell, if you could talk a little bit about is there kind of a narrative that you think of? I think an individual narrative of like what this looks like for someone who's held for a long time with on a bond they can't afford. I guess I'm just looking for sort of a human story around this.
Yeah, I think there are human stories on both sides. You have sides of folks who are incarcerated, who are waiting years for their case, and the overuse of pretrial detention has made those stories more, and it happens more and more often. You know, we've seen a 433% increase in pretrial detention between 1970 and I think it's 2015, 2016, right? And that massive expansion of pretrial detention has had an impact on the amount of time people wait for their cases to be heard. So I think it is a strong statement. I think it's a strong move to decide if someone is going to be detained, if we're going to take that step, which is supposed to be the exception to the rule. And that's not the Cook County Public Defender saying that's the exception to the rule. That's the Illinois Supreme Court, a conservative Illinois, not the Illinois Supreme Court. That's the United States Supreme Court. That's the United States Supreme Court saying that pretrial detention should be the exception and not the rule. If we're going to have that exception should be there because you had the prosecutor and defense attorney making arguments and a judgment making a risk-based decision, not just a guess about what type of money. So there are hundreds and thousands of stories of people who are waiting for their time to have a trial. And we know that because of that wait, oftentimes people will plead guilty, not because they're making an admission that they committed offense, because they're just sick of being in a box, right? They just want to get it over with. And it's unfortunate, right? It's something that we hate, but it's something that we got to be real about, right? We have to be real about the fact that our criminal legal system oftentimes isn't resolving things based upon the facts or the truth or evidence. They're making decisions because people just are afraid of waiting. And that's when you get into the issue of wrongful convictions and false confessions. That's when that gets really, really hairy. So I'm really glad that we are moving to a situation where we can have better decision making. And guess what? All of the things that get argued now, like the type of offense that there is, the person's background, all of those things, those prosecutors can argue. And we can argue about the person's background. We can argue about the person's size of the community. But the fact of the matter is we're having a real decision based upon, as opposed to a guess based upon money.
So that actually leads to a question we've gotten from the audience, and I want to throw this open, and maybe Mr. Rinehart, I'll start with you. Does the nature of the offense or the crime that someone is charged is, does that affect what the judge, or is that going to impact what a judge does in one of these hearings that'll happen after January 1st?
Yes, the hearings are relatively, there's a lot in the statute that describes the hearings, and that's a good thing because it gives the lawyers and the judges direct guidance. So we'll talk about, we'll talk about the offense. We'll talk about why the individual is a specific risk, why the individual can't be held on an ankle monitor or a scram device, for example, which is no alcohol, why that person can't be monitored by pretrial. I acknowledge that a lot of counties don't have that, right? So downstate counties don't have to talk about why somebody can't be monitored with a scram because they'll say they don't have scram. But at least in the counties that can afford it, like Lake County, we'll have to explain why a scram doesn't get the job done. So a good example of that is, well, if you say, well, somebody drinks a lot and that's when this crime occurs. The prosecutor's office has to explain, so why is the jail better than a scram bracelet? The scram bracelet is the thing they gave Lindsay Lohan a few years ago, so that you could see if she was drinking, right? The device detects the alcohol in the sweat, and then it notifies the courts, basically. So we'll have to explain, why is the jail better than a scram? There's sort of an idea that, well, scram's got to be more expensive. I don't know that it is more expensive than housing somebody in the jail, and we'll break down those costs. So so we're going to look at the nature of the risk. What is at the root cause of the criminal activity, right? That's an early way to look at some of these things. Maybe get people treatment earlier in time for certain types of offenses. So yeah, the offense will matter, and the individual facts of the case will matter, and what the individual has said about maybe a specific victim or what they said they intended to do. So we'll be able to get more specific because judges will have to explain it. And that's another added benefit of the reform. It's a transparency rule. Judges are saying numbers and moving on, but now judges have to articulate things. They will do this in these hearings. And instead of a market or a conveyor belt of just numbers passing by everybody, we'll actually have real conversations about our most serious cases. Not every case, about our most serious cases.
So your answer actually implicated another question we've gotten in a couple different ways, which is, what are the options for electronic monitoring or house arrest, et cetera, under this new law? Anybody want to take that one?
I can try to take it really quickly. So, currently electronic monitoring is in heavy use in Cook County and, not used as much in some other places. We know that there have been a lot of harms around, the use of the overuse, as we would see it, of electronic monitoring here in Cook County, and particularly the problem of people being put on like 24-hour house arrest without any freedom of movement. So that the judge has said you can be in your community, but you're not being given any movement to go outside of your house to get groceries, to pick your kids up from school, to go do the laundry. And so you have people who are literally incarcerated in their own homes and unable to meet their basic needs. And so the law, the Pretrial Fairness Act, changes that. And in fact, what it changes, the pieces of it that change this have already gone into effect, that basically require that people, if people are going to be put on electronic monitoring, they have to have a certain amount of freedom of movement to perform basic tasks. And also that, so often when people are found in violation of electronic monitoring, it's for something that wasn't really a violation, or that was a cause that was caused by faulty technology. And so there are, some guardrails that this puts into place around the worst, sort of most severe consequences being brought down on someone, like, reincarceration for a long period of time based on a faulty electronic monitoring. So we have a more protection for individuals who are placed on that form of pretrial supervision.
I think it's also really important to know that the vast majority of people who are on electronic monitoring comply with every single one of the terms, right? We see the failures on the news, but those failures are certainly outliers. They're important outliers, but they're outliers, right? If the news had to report on every time somebody complied with their electronic monitoring, there'd be no time for any other news. There'd be no other time for weather. There'd be no other time for traffic, and there'd be no other time for sports.
And we couldn't get those scary pictures.
Right, exactly. The fact of the matter is that we are living in an environment where when we have a 1% failure rate, you're hearing about 100% of those failures. And you hear about 0% of the 99. So there's no doubt that we need to have serious conversations about what happens when it comes to public safety. But again, going back to my earlier point, we need to be very specific that the current system allows for all of these flaws that we're talking about now. When you pull out a scary story that's happening right now, please be clear, you were talking about the system before the Pretrial Fairness Act. You're talking about the system where we allow money to make determinations about who should be in or who should be out. I will never make the argument that this new system will be perfect. On either end, there will be people after this system who will be incarcerated who I won't. But the fact of the matter is, on balance, this is a far better system than the status quo. And it's important to note that we need to protect the way it exists now and not give in to the misinformation, and not give in to the lies, and not give in to all of the incorrect pieces being explained, because we could find ourselves in a position where we would end money bond, but we would vastly increase pretrial incarceration, we would exacerbate racial inequities, and we will continue with all the ills. So let's do this thing, but let's do it right.
So can I just jump in here real quick, if you don't?
Please, yeah.
So I see that we're running out of time, and I just wanted to mention, to Sharone's point, and to the earlier point from State's Attorney Rinehart about the advantages of judicial economy, of focusing on those most serious cases and having a robust hearing. There is a proposal by, some of State's Attorney Rinehart's fellow prosecutors that's been introduced in Springfield, actually by a Democrat who lives in Carroll's neck of the woods in Champaign, that would do away with that differentiation between the most serious crimes that we need to be spending time on and the stuff that we're currently spending way too much time on and incarcerating people for no good reason. So that particular proposal, if we eliminate all that that focus and those guardrails that exist, we are very likely to see a system that incarcerates more people than we're incarcerating now, and that the racial disparities are even worse than the appalling ones we have now. And like State's Attorney Rinehart said, the appalling disparities are the whole reason this came to be in the first place. We cannot let the overall purpose of this important law, which was never just about ending money bond, but about having more fairness and more safety. We can't let that be undermined by and allow a system that's even worse than the broken, inequitable money bond system we have now.
Somebody on the way out, this is the last question. I'm sorry, we are running low on time, and I promise to get our guests out of here. Where does bond money go? Can someone answer that question quickly?
A lot of bond money goes to defense attorneys. who are able to use the money appropriately. So you post your cash bond, and then a lot of that money then goes to the defense attorney. That's not a bad thing right now, because that means you got to pay for your defense attorney and post cash bond. That's not a criticism of it, but a lot of it goes to defense attorneys, and a lot of it goes to pay old court costs. And so I see a question about the cost, at least in Lake County. We did add one prosecutor position, and we're not going to raise taxes because we added one prosecutor position. There was other savings throughout the entire county in our $600 million budget. And so I know it's not going to raise property taxes per se. We're going to reprioritize and reorient our resources. And I believe correctly that the legislature is telling the counties to spend more on safety and to spend more on equity. That's what this is. It is saying to reprioritize, dip into reserves if you have to, invest in people, and get this right when it comes to safety and when it comes to equity.
So I want to thank State's Attorney Rinehart, Cook County Public Defender Sharone Mitchell, Ben Ruddell, Carol Leff from our Champaign chapter, Ken Page from our Springfield chapter. I'm sorry we didn't get through everything that we had hoped to tonight. There's a lot to do here. Let me close by saying a couple of very, very important things. First of all, this issue happened because policymakers made it happen, and there'll be matters that will come up again about this in the veto session in a few weeks. If you care about this issue, if you care about other civil liberties issues, please vote. Early voting is open. You can register until the election day here in the state of Illinois. It is one of the really open and wonderful processes we have. And by the way, thanks to a bill that the ACLU worked on a few years ago, if you are actually in county jail awaiting trial, you can vote because you have not yet lost your ability and capacity to vote. And if folks like that can vote, so can all of us. I want to thank again these panelists who were just fantastic. I know that this is a very short period of time to discuss a very, very complex subject and to try to cover everything, but I really do appreciate you being part of this. And again, there's been lots of information in the links with more information about and other details about the bill, about actions you can take. I encourage you to do those. And thank you all very, very much for joining us today. And I hope you have a great evening. Take care.